I'll be fine. I mean, of course, we're holding the seminar during exams, and so it's understandable that people are busy. But thank you very much for being here today. We have the honor of having with us Professor Alessandro Spena, who's Professor of Criminal Law at the University of Palermo in Italy, and also, most importantly, a distinguished Nathanson visiting fellow this term here at the Nathanson Center. Professor Spena holds a PhD in criminal law from the University of, is it Macerata. He's also visited at numerous universities in Europe and abroad. Next summer he will be a visiting fellow at the University of Oxford, at Nuffield College, a Yemolo fellow. He's published 3 books, which I will not attempt to translate. Reati contro la famiglia. What is reati?
Crimes.
Crimes.
Family, yeah.
Crimes against family. Diritti di responsabilità penale. So I suppose law and penal responsibility.
Rights and criminal responsibility.
Rights. And il turpe mercato.
Oh, that's very difficult to translate. But
oh, okay. We will leave it at this.
The dirty deal.
Oh, I see.
Corruption.
I see. And obviously several articles. Recently, in Law and Philosophy, the strange case of the protective perimeter, liberties and claims to non-interference. Also published an article recently on harmless rapes, a false problem for the harm principle. So Professor Spena's main research interests are criminalization, as well as various aspects of legal, moral, and political theory, corruption, and intra-family crimes. And he served as a reviewer of numerous academic journals like Law and Philosophy, Punishment and Society, and Diritto e Questioni Pubblici. And so we're tremendously happy to have him with us today to present to us a paper on which he's been working during his time at the center this term, entitled Iniuria Migrandi, Criminalization of Immigrants and the Basic Principles of the Criminal Law. So the floor is yours, Alessandro. For how long do you think you'll be?
40 minutes.
40 minutes.
40,
That's good.
45 at maximum.
Okay, good. And then we'll discuss a little.
as you like.
Great.
Well, thank you, Francois, for your presentation. Thank you, everybody, for being here. And let me also thank Nathanson Center on Transnational Human Rights, Crime and Security for supporting my stay here at Osgoode Hall Law School. Well, okay, my general topic today is on criminalization of illegal immigration, which basically means the criminal enforcement of the state's alleged right to exclude foreigners, which is a strict sense to intend the concept of criminalization of illegal immigrants. Basically, I will focus on the fact that more and more frequently all around the world, the very act of illegally entering or staying on a state's territory is made into a crime. My focus will be specifically on European Union law, and in particular on Italian law on illegal immigration, although I am inclined to think that the very same principles can be found in many other Western countries' legislations. The aim of my talk today is basically an assessment from the perspective of a principled criminal law theory of the use of criminal law which is entailed in the criminalization of illegal immigration. The question to which I will try to answer is the following: what conception of criminal law does emerge from a consideration of these kinds of criminal norms? My thesis is that what emerges is an abuse of the criminal law in at least 2 senses. In the first sense, I'm inclined to think that those kinds of criminal norms amount to what in German language may be termed as a case, an instance of Täterstrafrecht, which means a criminal ban on persons and not on deeds. This criminal norms basically amount to a punishment of persons because of who they are, and not as individuals, but as a type of persons, and not to a punishment of persons because of what they do. In brief, these norms violate the so-called act requirement. And second reason, well, I think that this kinds of criminal norms amount to a perversion of criminal law in Anthony Daff's terminology, which means that they are cases in which criminal law is used to pursue non-penal aims or anti-penal aims. Okay, my lecture today will be basically will proceed in two steps. In the first step, I will set out the relevant legislation, and then in a second part, I will provide or try to provide a critical assessment of this legislation. Okay, a brief sketch of Italian law on legal, illegal migration. Quite unsurprisingly, in order to enter Italy, a specific authorization is required. This is an entailment of the state's alleged right to exclude foreigners. This specific authorization normally takes the form of a visa or residence permit and so on. And the obtainment of such a specific authorization is, in Italy at least, made conditional upon three requisites. Obviously enough that the foreigner's entrance be for a legitimate purpose. Second, that it be for a limited duration. And third, which is most important for my argument here, that the foreigner be already provided with sufficient means of support to keep himself during his stay and to go back to his country of origin at the end of the stay. There are obviously exemptions to these requirements. There is categories of persons who are not required to obtain a specific visa to enter Italian's territory. European Union citizens, obviously, but also nationals from visa-exempt countries, such as, for instance, Canada, and asylum seekers. But this is more and more made into merely a theoretical exemption, because it is more and more frequently becoming very difficult to obtain asylum seeker status, at least in Italy and in Europe. From this brief sketch, it is possible to derive as a consequence that if you are not either a European citizen or a national from a visa-exempt country or an asylum seeker, and second, you are not provided with sufficient means of support, well, the only way you have to enter or to try to enter Italy is by trying to do it irregularly. Then what does it happen if you try to enter Italy irregularly? Basically, the consequences are two. The first consequence is that you commit the crime of illegal entrance, which is made punishable by Article 10 bis of the Italian Consolidated Law on Immigration, with a fine ranging from 5,000 to 10,000 euros. But this fine, the application of this fine, is substitutable with judicial expulsion, which means that the judge may decide to substitute an expulsion of the illegal immigrants for the fine. Second consequence, the foreigners who illegally enter the state's territory are liable to be administratively expelled. That is, they are liable to be expelled directly by the police. Important, at least from my point of view, expulsion, both judicial or administrative, is clearly preferred to the actual punishment, that is, to the application of the fine to the illegal immigrants. And second, administrative expulsion is clearly preferred to both the punishment and judicial expulsion of illegal immigrants. In other words, this is a point on which I will return shortly. In other words, police's intervention is preferred to the intervention of the judges and of the criminal trial. Indeed, illegal immigrants must be administratively expelled as soon as possible, irrespective of whether they are already on trial for illegal entrance. If they are already on trial for illegal entrance, well, the judge must bring the criminal proceeding to a close with a sentence that in Italian is called a non luogo a procedere. This means that the judge should acquit the defendant, but without entering into the merits of his alleged responsibility, but simply because the state has no more interest in proceeding and in trying him. Third, detention in so-called centers of identification and expulsion, CIE. Detention in these centers is admitted as a means to administrative expulsion, but it is not admitted, detention is not admitted as a punishment of illegal immigrants, nor is it admitted as a means to judicial expulsion, because the judge may only substitute expulsion for the fine if the illegal immigrants is immediately rebuttable. Okay, what does it happen at European Union level? The principles are basically the same. First of all, it is explicitly stated that border control is a member state's duty, since it is in the interest not only of the member states at whose external borders it is carried out, but of all member states which have abolished internal border control. The general rules for foreigners' admission in European Union territories, well, are basically the same as Italian law. And so specific authorization is needed, visa or residence permit, of course, basically the same exemptions are provided, but if you are not exempted, if you are not subsumable under one of the categories of exemption, in order to obtain a visa or a residence permit, you must have, again, sufficient means of subsistence, both for the duration of your intended stay and for your return in your country of origin. Those foreigners who do not fulfill the established conditions, obviously enough, should be refused entrance, but if they all the same try to enter or succeed in entering irregularly, they must be expelled according to the rules established in the so-called repatriation directive. As to the criminalization of illegal immigration, European law does not require that states enact norms criminalizing illegal immigration, but neither does it ban this possibility. In sum, the criminalization of illegal immigration is in principle legitimate from a European law perspective, but, this is very important, but only insofar as it does not negatively affect illegal immigrants' prompt expulsion. This is a point that recently the European Court of Justice has repeatedly dwelled on. There is a sentence, a judgment that has been laid last Friday, according to which the obligation imposed on the member states by the repatriation directive to carry out the removal of illegal immigrants must be fulfilled as soon as possible. And that will clearly not be the case if, after establishing that a third country national is staying illegally, the member states were to preface the implementation of the return decision with a criminal prosecution followed by a term of imprisonment. Such a step will delay the removal. So what is the overriding aim of the European law legislation is the expulsion of illegal immigrants. As a result, illegal immigrants' detention is, from a European law perspective, certainly legitimate as an administrative means geared to carrying out their expulsion, but it is illegitimate as a form of punishment to be enforced during the course of the return procedure, because this will be likely to negatively impinge on a prompt illegal immigrants' expulsion. Now, this is a brief sketch of the relevant legislation. Now I move on to the critical part of my lecture today. The first kind of problem that this legislation raises from my point of view, as I said, is that as to criminal law, this amounts to so-called Täterstrafrecht, or, as I said, a criminal ban on persons and not so much on their deeds. One might translate Täterstrafrecht with the label actor, criminal law, as opposed to act criminal law. Well, formally, the relevant criminal norms, such as Article 10 bis of the Italian Consolidating Law on Immigration, formally these norms are constructed so as to revolve around the commission of an act. The formal structure of the norms is deferring to the act requirement. For instance, Article 10 bis states that must be punished with a fine the foreigner who enters or stays, so basically acts or omissions, enters or stays on the state's territory in violation of the norms of the present act. However, at least this is my point, however, in the logic of that norm, the conduct only enters the picture not really as the intentional object of criminal responsibility, but as a way to point out the allegedly inherent criminality of those persons fitting the stereotype of the illegal immigrant. To clarify this point, we need to go beyond the mere structure of the norms criminalizing illegal immigration and expand our view so as to encompass the more general traits of states' regulations on legal and illegal migration. From this more comprehensive perspective, it should become quite clear that those regulations are usually set up in such a way as to make only certain categories of migrants qualify as illegals. Indeed, putting aside the possibility of obtaining asylum seeker status, regular entry in European states at least depends, as we have seen, either on being a national of a visa-exempt country, which from the point of view of many rich Western societies basically means being a national of another rich Western society, or second, on being provided with sufficient means of subsistence. As a result, only certain categories of persons qualify as possible targets of an illegal immigration crime. Basically, the poor coming from non-visa exempt countries. In other words, a crime of illegal immigration, at least in European legal systems, refers to poor migrants coming from Africa, Near East, Asia, and in part Eastern Europe as its specific stereotyped author. The fact that this kind of crime is built upon the commission or omission of a certain type of action does not save it from ending up being a criminal ban on certain types of persons because of their poverty or geographical provenance. In other words, while on the one hand, the crime's formal structure revolves around a specific type of conduct, illegally entering or staying on state territory, the state's regulation on illegal migration, on the other hand, is constructed in such a way as to make the illegality of such conduct, and thus its being a crime, a function of the personal and social conditions of those who commit it, of their being nationals of certain countries, and of their lacking sufficient means of support. There is more to this point, because the illegal immigrant stereotype encompasses both a descriptive and a normative side. Given the descriptive traits of the stereotype, the immigrant's poverty, he is coming from a non-visa exempt country. Given these descriptive traits, the normative assessment of illegal immigrants as dangerous and deviant persons is at hand and ready-made. That migrants coming from poor countries and lacking sufficient means of subsistence, once they have entered the state's territory, will be compelled by their very poverty to commit crimes in order to support themselves, is a pretty easy conclusion to draw. Hence, the qualities of being undesirable, dangerous, criminal, are inescapably tied to the illegal immigrant stereotype. More precisely, the stigmatizing force of the illegal immigrant stereotype takes effect in two different stages, each one reinforcing the other. In the first stage, the stigmatization of certain categories of immigrants works as the social and political basis for the very construction of the stereotype, and therefore as the purported justification for criminalizing illegal immigration. In sum, we punish illegal immigrants because, being poor and non-civilized, they are dangerous to our societies. In a second stage, however, the very existence of the crime of illegal immigration and the fact that only certain categories of migrants can commit it serves to confirm and reinforce the stereotype's normative side. That is, the idea that illegal immigrants are inherently criminal and cannot help committing crimes. The impression of a criminal stigma on illegal immigrants works then both as a presupposition, a ground in reason, and as an effect of the criminalization of illegal immigration. By criminalizing the very fact of irregularly entering the state's territory, the social stigma of being criminals is attached to certain categories of persons, and this transitively invests these persons with the very same invidious meanings, labels, qualifications that are socially attached to the concept of criminality. Criminals, or deviants, dangerous persons, and so on, clandestines are, by definition, criminals, being the author of the crime of illegal entrance. Thus, hence the conclusion, clandestines are deviants, dangerous persons, and so on. I want now to go a step further and argue that, paradoxical as it may appear, the most relevant reason to be worried about here is not just that illegal immigrants are subjected to criminal law, but on the contrary, that they are not really subjected to it. That their criminalization is functional precisely to taking them away from criminal law, from its rules and principles, and subjecting them to non-penal, administrative, purely preventive power. In a way, there is too little criminal law at work here. To be sure, I'm not advocating the introduction of more criminal norms dealing with illegal immigration. I am rather complaining that those criminal norms that in fact exist are nothing but mere facades, merely functional to covering and legitimating other kind of practices and mechanisms that have nothing to do with criminal law. This conclusion can be easily drawn if one considers that norms such as Article 10b are so structured as to be completely unable to attain the canonical criminal law's aims. How could such a norm ever claim to have, for instance, any either general or specific preventive effects? Punishing illegal immigration with a fine ranging from 5,000 to 10,000 euros is a very curious way of attempting to prevent illegal entrance by persons, such as illegal immigrants, who are by definition, by legal definition, lacking sufficient means of support. From very crime's legal presuppositions, poverty as a constitutive requisite of the crime, there therefore stems the practical impossibility of enforcing the punishment officially tied to the commission of the crime itself. The norm, in fact, amounts to the announcement of a non-punishment, and no one will be obviously deterred by it, since, according to the very logic of deterrence, no one could be deterred by the prospective non-infliction of a sanction. But there is more to this point. Not only does the punishment for illegal immigration seem to be completely unable to attain any kind of preventive effects, everything in this microsystem texture seems to conjure against its judicial application, favoring instead the application of expulsive mechanisms. In the law's general design, indeed, immigrant expulsion, as I said earlier, is clearly preferred to their actual punishment, as can be easily inferred by the fact that as soon as they enter, illegal immigrants are liable to be administratively expelled directly by the police, and the administrative expulsion by police is immediately executive, irrespective of whether the foreigner has or not been already charged for the crime of illegal immigration. And importantly, as I said, if the foreigner is already on trial for the crime of illegal immigration, the judge, as soon as he is informed of the administrative expulsion, he must declare that there are no more reasons to proceeding. In other words, administrative expulsion preempts illegal immigrants' trial and punishment. And as soon as the alleged illegal immigrant is expelled, the state is no longer interested in prosecuting and trying him. More generally, it seems that punishing illegal immigrants, either by fine or by judicial expulsion, and thus putting them on criminal trial, is not among the crucial points of the regulation of illegal immigration. The system seems to be uninterested in subjecting these persons to criminal justice and criminal law for the crime of illegal immigration. This is an important caveat because when it comes to other crimes, such as drug crimes, the law seems instead to be particularly eager to put immigrants in the penal system's ward. But as to the crime of illegal immigration, instead, the system is not really, seems to be not particularly interested in subjecting these persons to criminal trial and punishment. This is, I argue, a particularly telling circumstance, overtly indicative of the way in which our legal systems conceive of illegal immigrants and of their personal moral standing. Both criminalization of illegal immigration and its intended judicial unenforceability, or at least residual enforceability, manifest the very same dehumanized conception of illegal immigrants as non-persons. Let me dwell on this point. Criminal law is, in a way, based on social resentment, insofar as it revolves around the commission of public wrongs and thus entails a public condemnation of those who are deemed responsible for committing them. The act of punishing wrongdoers is an expression of such resentment, and the criminal trial is a way of coming to terms with it, a grieving process for social resentment. This makes criminal law into a kind of law strictly intertwined with morality, resentment being a moral emotion that triggers moral reactions. Because of its being a moral emotion, resentment also expresses concern for the person against which it is directed. Feeling resentment against a person entails attributing to him a moral standing, treating him as a moral subject. We are interested in his moral word, and this is why we call him to answer for what he did. We expect or even require him to explain his behavior, justify himself, plea for an excuse, and so on. In brief, we require him to engage in a moral dialogue with us, the public, society. Therefore, we put him on criminal trial, which is in fact a manifestation of interest in what he did and in what he has to say about it. But when it comes to the crime of illegal immigration, resentment seems to be supplanted by annoyance or indifference at most. The legal system, as we have seen, shows no real interest in prosecuting the alleged authors of the crime, nor in punishing them. The real aim being that of expelling these people as soon as possible, or at any rate, making them liable to expulsion, so as to put them under the administrative dominion of the state, a dominion far more extensive and intrusive, and far less principled than that to which a criminal conviction may give rise. By criminalizing illegal immigrants for their irregular entrance or stay, while at the same time taking them away as far as possible from the judicial ascertainment of their crime and responsibility, the law shows it is merely interested in constructing these people as illegals, as instances of a dehumanist stereotype, and not in calling them to answer as moral agents for the crime they are charged for. The legislator is content with the mere impression of a criminal stigma on illegal immigrants, for this enables him, politically and socially, to keep these people under legal and administrative domination in a purgatory where they can be easily managed for the state's own purposes, a largely populated limbo where they will remain until they either see the light in virtue of one of the ever-recurring regularizations, or more or less causally are picked out to be expelled. To conclude, criminal law is, at least from my point of view, is thereby abused, perverted. It is used as a mere camouflage geared to pursuing or to legitimating the pursuit of non-penal aims radically conflicting with those that a principled criminal law should properly pursue. A mere facade designed to cover with a typical criminal law's legitimating mantle a system of administrative measures aimed at reducing illegal immigrants to the dehumanized condition of non-persons at the mercy of the state. Thank you.
Thank you very much, Alessandro. So we have lots of time for discussion, and so we'll open the floor for questions. If you have thoughts, comments, critiques, or anything that comes to mind. Professor Styrbopoulos.
Kill me softly.
You'll have to use the microphone if that's possible, simply because we're recording. Thank you.
I really enjoyed your talk, and
Please kill me softly.
what was that? Sorry.
He wants you to kill him.
Oh no, I'm not killing anyone. Don't worry. Actually, just a question of clarification. So, with the offense in Italy of illegal entry, you mentioned that if they choose, in theory, to pursue criminal charges, the punishment available is a fine, not imprisonment?
No.
Is that unusual in terms of criminal offenses in Italy? I just wonder because we have had this long-standing debate in Canada about regulatory versus criminal offenses, the distinction between the two. I teach criminal law, and I'm not entirely sure what the distinction is, to be perfectly frank. But one of the key distinguishing features that we often fasten on, and it's less than clear, frankly, because we have a lot of regulatory offenses that have this feature, and we don't really have criminal offenses that don't, but jail is usually the way we do. We have regulatory offenses that send people to jail, but we don't have any criminal offenses that don't send people to jail. So I wonder whether that's true in Italy too. Just curious.
Or leave the option of sending to jail.
Well, there has been a lot of debate in Italy over the last decades, I would say, about economic punishment, fine, and as an alternative to jail or to imprisonment. At the moment, fine or economic punishments are widely used in Italian criminal law, and the distinction between imprisonment and economic punishment or fine does not trace the distinction between, most serious crimes and less serious crimes. In Italian criminal law, we have a general distinction between crimes in the strict sense and so-called contraventions that are approximately regularly offenses, approximately, because but also regulatory offenses are punishable with jail in some cases, and also crimes are made punishable with fine.
So your approach is just as inconsistent as our own then. It sounds very similar to the Canadian.
Sorry?
It sounds very similar to what we do in Canada, in fact.
Okay.
There's lack of coherence. So I'm just curious then, this is truly treated like, unlawful entry is treated like a true crime. It's not treated like a contravention in Italy.
No, it is a contravention.
It is a contravention.
Yeah, but it makes no difference in it according to Italian law, because contraventions and crimes are, or better still, serious crimes and contraventions are both crimes. You can find them both in the criminal code.
Yeah.
And they are expressly labeled as crimes by our criminal code. So it makes no difference. There is only a formal difference between, some formal differences between crimes and contraventions.
So it's your thesis that they put illegal entry into this category of crime for the sake of stigmatizing those who enter illegally, so that they can justify dealing with them expeditiously through administrative means. It's a way of justifying not affording them more due process.
Yeah, from my point of view, this is the question. basically criminal norms are enacted, but there is no real interest in enforcing them. So it is a way to tag these persons as criminals, because this renders easier from a social point of view, from the point of view of the public opinion, if you want, the fact that we treat these persons as criminals, but as criminals in a non-penal way, criminals without the rights of the criminal, so to say.
But couldn't we flip this around? Couldn't we say, well, the prime remedy to illegal entry is we send you back. It's expulsion.
Yeah.
Now, if the government, for whatever reason, decides that it's not going to expel, only then is it really going to be the case that there is a so-called trial for the crime or the contravention of illegal entry. And so it's really, as you say, a subsidiary means of, as it were, sanctioning the conduct. So couldn't we say, well, actually, that's a means for the government to exercise leniency, to say, in some cases, it's not going to send back the illegal immigrants to their country, but it's still going to say, to save public face, well, this was still not according to the rules. We're going to fine you, and the fine. I mean, it's a significant fine, but it's not tremendous, right?
Oh, but it's significant. According to the standards of Italian criminal law, it is a significant fine.
Right, but even acknowledging this, couldn't we simply say, well, this is a way of basically saying we're enforcing the rule, but we're not really enforcing the rule. We're not sending them back. We're simply saying you shouldn't have done this, yet you can stay.
Oh, well, this might be a way of putting the question. Clarification. Italy cannot decide, or Italian government cannot decide not to expel these persons, because it is an obligation imposed by repatriation directive.
So the question is only when they will expel. Is it before conviction or after conviction?
Yeah.
Okay.
And the question is, if they are able, if the government is really able to expel these persons, because it is not easy to identify many of these persons, and this makes the expulsion procedure particularly problematic, which in fact causes that frequently expulsions are not really carried out.
Okay.
So what you have, this masses of persons who are irregular, who should be expelled, who are, because if the government or the police does not succeed in expelling them, they are invited to go away. There is an order directed to these persons, insofar as the government is not able itself to carry out the expulsion.
So what does that mean? The government is not able to carry out the expulsion? Because it's true that France or Italy have millions of what the French call sans-papiers, right? People who are simply there, and they claim that they don't have the resources, presumably, to throw them. Is that what we're talking about?
Resources, or because they are not identifiable.
Okay.
So you cannot send them in a country of origin if you don't know which is their country of origin.
And in these cases, are they mostly tried? Or again, is it the case that the state mostly doesn't try these people? That most illegal immigrants who are not deported are also not tried?
In fact, they are not really so frequently tried.
Okay.
Not really. Well, what happens is basically annoyance and indifference.
Right.
There are not so many. There are many criminal trials against illegal immigrants, but these trials frequently regard different kinds of crimes, such as drugs crimes, for instance.
So if I may push you a bit further, what would you envisage as the ideal system in this case? And that might tell me a bit more about what you're thinking, right? Do you agree with this idea that one should expel first and criminalize second? Or would you want all these people to be criminalized? Or so how do you see the model sort of regulation of this situation? as working?
Well, I see it as a perversion of
Right.
criminal law.
Right.
But quite ridiculously, it is a perversion of criminal law which is different to one of the most important criminal law principles, which is the criminal law as a last resort. Because in the case of illegal immigrants, the criminal law is, as it is shaped in European Union law, or at least in Italian law, criminal law is the last resort, because we do not want really to treat them according to criminal law. So it is the last resort, but the reasons for which it is the last resort are not the noble reasons for which the principle of criminal law as ultima ratio is generally proclaimed.
Okay.
And I think it is a perversion in the sense that it is a paradigmatic case in which criminal law is improperly used. It is used to attain contingent political aims, contingent political success, if I can say so.
What are those contingent political successes that you have in mind? So what would be the reasons, just to clarify?
Of the political success?
Yeah.
Well, is the fact that more and more people, persons, citizens in Italy tend to see immigrants as a threat.
Right.
On the one hand, as potential inherent criminals, and on the other hand, as persons who can steal the work, the job from citizens.
So who are these people that are tried? That's what I'm trying to understand. So presumably the primary obligation is to deport, right? Repatriate, send people to their countries, right? So,
Yeah.
so presumably that's, if the resources are in place, then that's what happens.
Yeah.
So when that's not carried out, there's a number of individuals that remain. Are those the individuals that are tried? Or so who does the government focus on when it's trying people for illegal entry? Is it people that it could repatriate? Is it people that it cannot repatriate because it doesn't know, for example, the country of origin?
Oh, it is.
Is it, as you say, for example, just poor people, or is it?
Oh, they are all
Okay.
poor people. Let's.
So why are they all, again, just, I don't want to divert the question here, but why are they all poor? It could be that somebody goes in illegally that as means to go in, but just doesn't have the visa, right? And they would be in the same.
Oh well,
boat.
that's probably possible in theory, but
Okay, so you
that's,
say in
that
fact
never
it's not.
happens
Okay.
in practice.
So who are these people
It
that are
is
tried?
as with vagrancy, for instance.
Right.
In theory, you can have rich vagrants, but no one will
Okay.
never.
So who are there studies as to who the government chooses to try? Is it just a political tool
No.
that is used to
No, no,
target
no.
certain
No,
groups of people?
we
No?
do not have, at least in principle, we do not have a discretionary exercise of criminal proceeding, of criminal investigations. So that magistrates, prosecutors are obligated to prosecute every crime they know of. So there is no, at least in principle, there is no choice, political choice made about it. Simply, as far as I can see, because as far as I can see, it is a causal
So is it
picking out these persons.
So is it the case that every illegal migrant, at least in principle, has a criminal case started against them?
Uh-huh.
And the question is just how far that case will extend, whether they're
Uh-huh.
going to be deported right away or whether they're going to allow this person to appear to court and to go through the process.
No.
So-
If they can be expelled, they have to be expelled.
So if they can be expelled, they're expelled without a criminal prosecution being
Absolutely.
started. Okay.
Absolutely. The judge cannot do anything. Cannot say no. 1 moment. I have to try this person and see if he really is an illegal immigrant.
So the people that are tried then are the people that cannot be deported for whatever reason.
Yeah, Yeah, you can say this. Right?
Are there many trials? Because it sounds like there aren't.
Sorry?
Are there very many trials? Because the way you present it sounds like there would be very few trials under this.
I don't think there are many trials for illegal immigration.
So I think my sense of your thesis then, just to go back, is that the label of criminal is deployed to justify resort to administrative procedures for expulsion that are quite deliberately designed not to afford due process.
Yeah.
So we label them criminals, and therefore we can feel good about treating them in an administrative fashion and not giving them the panoply of due process protections they'd be entitled. So it's just, like you say, deployed for political as opposed to principled reasons.
But it seems to me that has to be the case simply because if the reason for them to be tried is they cannot be deported, then the government says to itself or says to the population, I need to do something, qua government, and that is to try them. Right? As a result of a criminal prosecution, are there sometimes deportation?
Sorry?
So people cannot be deported. So people who can be deported are deported. People who cannot be deported, presumably, are tried.
Yeah, presumably, but it does not happen
so when they are tried, the remedy is a fine.
Yeah.
They cannot be then deported as a result of.
No, they can, but if they are deportable.
If they are, if they were deportable, the assumption was if they're
of course. This is paradoxical.
But
I would
imagine it's like here, where
the fine can be substituted with judicial expulsion only if they are if they can be expelled in the first place. But if they could be expelled in the first place, there would have been no criminal trial.
Right.
The only situation we find ourselves in where we can't deport people that we want to deport are those who would face torture, where we're sending them. So and that's what we've used the security certificates, and people are subject to strict controls in the community and on bail because they're subject to security certificates. I would imagine there must be something similar in Italy for similar reasons. I mean, they've signed the same international commitments to not subject their nationals or foreign nationals to torture. I would imagine you won't deport someone to face torture.
Yeah, but I do not really see the question. Could you?
So the question is, Francois was trying to imagine a situation where someone was illegal, but you could not expel them, and therefore you were going to try them, but you couldn't expel them. And the only situation I can envision, just theorizing about it, is someone who would be expelled to a country where they would be persecuted, where they would be killed or tortured.
You would have stateless people also.
Oh, but
right, people who have nowhere to go back to.
That's right.
Okay, so.
Yeah, these people should have been afforded an asylum seeker. Asylum. Oh, sorry, asylum seeker status. This should be in theory.
So torture would be a good case.
Yeah. No. This in theory would not be illegal immigration.
Yeah.
Right. They would, in principle, probably be exempt from some.
Microphone, if you.
Oh, sorry.
They would, in principle, probably be exempt from some of the quasi-criminal sanctions that would otherwise apply to them. I would imagine. I mean, it's the same here, where people who are found to be genuine asylum seekers are then, and this comes from the Refugee Convention, are exempt from punitive measures that they would otherwise be subjected to because of the illegal nature of their entrance.
Yeah.
I assume it's the same in Italy, probably.
Yeah.
It's a signatory to the convention.
Yep.
I have a question. First of all, I'm not sure how much you've been following developments in Canada over the last little while. How long have you been in Canada for?
Oh, 2 months.
2 months. So this is, I mean, you have a gold mine of activity here in Canada to look into in terms of the graying of lines between criminal law and immigration law, because it's a direction that we're explicitly heading into in many ways in Canada, where you have new provisions just coming into effect this week, in fact.
Oh, but is there a crime of illegal immigration in Canada?
Well, it's complicated. What you have is an immigration regime that is regulatory in nature, but that does have components to it that are criminalized. So infractions mostly for the illegal use of documents or smuggling events,
Yeah.
are tied into criminal code sanctions.
Yeah.
But then run-of-the-mill immigration infractions are dealt with administratively, and historically, Canadian policymakers and decision makers have avoided the language of criminal law and the language of a punitive kind of element to immigration law. But that has melted away, and it's melted away very explicitly. So in Canada, over the last couple of years, you've had events like and probably most people have heard about it here because it was in the news, the release of a most wanted list, a list of people, like straight out of the Wild West in the United States, a list of kind of swarthy-looking men, unshaven, who are war criminals, people who have committed crimes against humanity, serious criminals. These are all people, of course, who have been found to be such in the immigration regime, so of course subject to a very low standard of proof, and I assume it's the same in Italy. You also have these new mandatory detention provisions, and so people who are now designated to have arrived in Canada by way of a smuggler, by way of being people smuggled, are subjected to mandatory detention of at least, generally speaking, they'll have a review, but generally speaking, at least 6 months up to a year, up to much longer than a year. And the interesting thing you see is that immigration officials are very explicitly moving away from the administrative law language of immigration towards criminal law language of immigration. So,
Why do you think is this happening?
why is it happening? This gets to my question actually,
Oh, okay.
which is that it's happening very clearly.
This is my answer.
As a deterrent, like much of the changes that are being made are being very publicly messaged, it feels very much like a public relations campaign, both domestically and to those who would come from outside. My sense is that it is entirely for deterrence purposes. And so, I mean, deterrence, of course, is such a core principle of criminal law. And so you have, on the one hand, administrative law language, but it's now being suffused with the language of deterrence. And so I'm wondering, my question for you is whether or not you think that's also something that happens in the EU, whether or not some of these sanctions that can be brought to bear on illegal immigrants are messaging, are to send a message to those who would think about coming, stop, think about it before you do, because you will be subjected to stigmatization and this kind of punitive nature of illegal immigration infractions.
No, I don't think it is. Deterrence,
Yes.
the law's aim, absolutely. It cannot be, but in the first place, because of the punishment that is threatened, it is absolutely lacking deterrent qualities. But I think that the real problem is not that of, at least from a political point of view, is not really that of deterring these persons to entering the Italian territory. The real point is that of creating a non-legal status where these persons can be usefully managed, because illegal immigrants are particularly useful for the Italian economy, for instance. A great bulk of the Italian economy is based on illegal immigrants' irregular job. And no sufficiently smart government will really want to put them away, because they are, in good part, what makes Italian economy go on. And so, in my view, the problem is, or at least the political aim is not really that of expelling these persons, but making these persons liable to expulsion, which is worse. because they are, in fact, admitted to remain, but in a particular condition. De facto, they are non-humans,
In a zone
and
of
they are
illegality, yeah.
extremely useful for economic aims, first of all. So I don't think that deterrence is the real aim of this.
Well, as I say, this is a
policies.
new thing here. I mean, but it's entirely clear. In fact, the Minister of Citizenship just had a press conference 2 days ago or last week after the detention of foreign nationals, and he said, "This is meant to be a deterrent to those of you who would enter without following Canada's immigration rules." So,
Do you really think that that's a message he intends to be heard by the people who might enter, or do you think it's a message he intends to be heard by the Canadian population who wants him to be seen to be taking a hard stand against illegal immigrants for the very same reason that Italians want
Yeah.
the government to be seen?
Yeah.
You know, the reality is it's being deployed for political purposes.
Yeah. Peanut populism.
but it's both. I mean, it was done in Hungarian and
Well,
Romanian.
I think they are in fact targeting Roma in particular. They
Yeah.
really got their sights, and there's a lot of stereotyping that's going on in that regard, you know, on the part of the government and on the part of the media. But I do think that a lot of that is really this government's effort. It's the very kind of stuff they've been doing in criminal justice as well, which is it's not about effective criminal law in Canada. It's about effective politics in Canada.
It's messaging.
It's messaging.
I mean,
yeah.
look to the names of the acts. And
Oh,
they're
yeah.
both criminal law and immigration law.
Yeah.
Right? I mean,
It's crazy. It's so transparently political.
Yeah.
Truth in sentencing act, and things like that. Give me a break. Anyway,
William.
here, I'll pass it.
Thank you. I've really enjoyed this. Very thoughtful. I'm guessing that you're using Agamben. If you're not, you're pretty close. So, are you using Agamben?
No.
Okay. Well, Agamben's an Italian philosopher that writes on this idea of creating the non-person.
Oh, Agamben. Okay.
Oh,
okay.
sorry, I
Yeah. It was
all
the
in the
pronunciation.
intonation.
It was the pronunciation.
Yeah,
Okay.
so-
Yeah.
So
I've
you
read
are
it.
using
Almost
it.
accurate. Yeah.
Yes.
Yeah.
Okay.
I'm not sure I've really understood him, but that's another point.
Right. That is another point there too.
But
And
I've
I'm
read it.
someone else who uses Agamben.
Sorry.
Try to get
Yeah.
the pronunciation right, is Alison Mounts, who's a U.S. Academic who's actually Canada chair at Wilfrid Laurier, and she talks about the performative state, which fits with some of these comments, the idea that the state itself is performing something for various audiences. What I wondered, because you said that this is the creation of the non-person of the poor, and you're specifically meaning the poor who are not citizens. And I'm wondering, what are the implications of this weakening of criminal law? And I say this I'm not a lawyer, I have no legal training, I'm a social scientist. What are the implications for Italians who are poor, who are Italian born?
Oh well. Well, in fact, there are different kinds of implications. A first kind of implication is merely symbolical, because, well, at least theoretically, Italian poor citizens are treated in principle better than immigrants, and this, in a way, symbolically confirms that they are citizens. But this is an only formal and symbolical result. What does happen is that, for instance, there are many ways in which Italian citizens can be indirectly criminalized as a result of the criminalization of illegal immigrants. For instance, there is a crime that explicitly punishes, I think, with imprisonment, those Italian citizens who give a home. At the moment, I cannot find the word, but to give an accommodation in change of money to illegal immigrants is a crime. And this is just one of the possible consequences for Italian citizens of the very fact of criminalizing illegal immigrants. And I think that there are many, many other consequences that indirectly can affect Italian citizens. For instance, it happens more and more frequently that specific kind of procedural measures are created in order to deal with illegal immigrants, but it frequently happens that this kind of measures can also apply to Italian citizens. And thus, what I can surely say is that a crackdown on illegal immigration causes as a result a weakening of the criminal law standards and principles also for the Italian citizens. And this is a side effect, obviously, but it is an effect. And I don't know if this meets your point. As to Giorgio Agamben, but probably he has a lot to say about the criminalization of illegal immigrants. His thesis being, insofar as I have understood it, because it is really complicated. I don't know if you have read him, but insofar his thesis is that sovereignty revolves around the fact of making persons into so-called homini sacri. Homo sacer is a Roman expression that refers to a sanction in Roman law. The authors of certain kinds of crimes were punished by being made into homini sacri, which might be translated with sacred persons. But being sacred in Roman law was not a good thing, because this implied to be banned from the polity, and being banned entailed that the person might be killed by everyone. The person was reduced to a non-person, and thus everyone could. It was something like a death penalty executable by everyone in the polity.
Would it be similar to what Americans or British people called outlaws?
Yeah, something so. Okay. And probably in some possible interpretations of Agamben theory might fit my interpretation of
It's not
illegal
quite
immigration.
the same as outlaw, though.
Yeah, no. Okay. You see, you refer to the concept of outlaws.
Yeah, it's not quite the same.
Okay.
But,
Could you explain?
well,
me?
because for the homo sacer is both within the law and outside the law at the same time.
Yeah. It's at the margin, of between law and outlawry, maybe. I don't know.
But it would remove your protection. So if you're a Roman citizen, you couldn't be murdered. But if you were,
Microphone, if possible. Sorry.
So this would put you in a subordinate position.
Yeah.
Or the protection of Roman law wouldn't apply to you.
Yeah. You are basically sentenced to. This is not the Agamben theory. This is the Roman law.
Roman idea, yeah.
Yeah. You are sentenced to death, basically, but it is not the government, so to say, that executes this sentence, but it is everyone that is legitimated to execute it. So you simply it is better for you if you go away from the polity, in a way. And thus, in this sense, it's a kind of punishment.
I mean, outlawry was created for the same reason, right? There's some people that the states could not catch and could simply not prosecute, knowing full well that they had committed atrocities, saying, well, if we can do it, then everybody can go out and catch that person, right? So it's similar, but the term outlaw implies that they are completely outside the law. It's not really the case, right? They're declared outlaws for violations of laws, as it were. So, more questions? If not, I do have one more. You had two main problems, right, with the legislation. One was this perversion of the law, which we've just discussed, and the other that is that you think that illegal entry as a crime is a status crime, as it were, where you punish somebody for being who they are, as opposed as punishing them for something that they've done, for wrongdoing. For
It is a punishment for wrongdoing.
Okay, and I wonder if that's really the case, because we're actually talking about unlawful entry, right? So if I enter James's house without James's consent, I am guilty of unlawful entry. If a police officer goes into James's house with a warrant, that's not more unlawful entry. So how is that case different from the case of an illegal immigrant who enters without the right papers? As opposed to me, the citizen who enters the country with a passport.
Well,
because there is this case in the UK, the Larsener case, where somebody, but that's a very different case. It's somebody who ends up being without status illegally in the UK because that status is withdrawn from that person while they are in the UK. So there's nothing they can do, right? So they're punished for being there, right? But in most cases of unlawful entries, when we're talking about smuggling and things like that, there is an action, right? So that aspect.
Of course.
Okay.
Well, in the first place, I do not really sympathize the analogy between state and home. I don't think that entering a person's home is quite the same of entering a state's territory. I think that there are different kind of values and implications in the two cases, but this is a point I will not dwell on in trying to answer your question. Well, in my view, it is certainly true that these crimes are formally structured, and they formally revolve around the commission of an action. No doubt about it. But as far as I can see, or at least from my point of view, this is merely considered by the law as a symptom. I will talk about it, but there are two theoretical possibility of intending of given sense of the concept of actor criminal law or täterstraffrätt. There is a first possibility that is so-called pure täterstraffrätt, that is the case of pure actor criminal law, which is the case in which persons are directly punished with no reference to whatever they might have done. For instance, think to Cesare Lombroso's theory of the born criminals. This is a theory. Cesare Lombroso was an Italian criminologist, quite famous also in Anglo-American ambit. But his theory was that some persons are inherently criminals, and you can see that by simply a physiognomic assessment, so to say, by certain traits of their face. Lombroso thought that he could infer the inherent criminality of this person. So, okay, this is a case of pure actor criminal law. But the most problematic instances of actor criminal law are those of so-called spurious actor criminal law. That is, pieces of legislations are examples of thought in which you have an act, but the act is not the intentional object of criminalization, but it is simply a symptom to catch the actor behind it. For instance, many Nazis, pieces of legislation had this kind of structure. For instance, there is an important German Nazi criminal lawyer, Georg Dahm, who is among the most important advocates of a Täterstrafrecht, who makes this example. He says that a thief is not anyone who steals something from another person, but a thief is only he who is a thief according to its own nature. So you need an act, in a way, but you do not punish the act as such, but you punish the fact that that person is a thief. Well, think for instance, but I could imagine of an example in order to try to explain my idea of a Täterstrafrecht at work in the case of illegal immigration. Think of a law, of a criminal norm that punishes whoever buys punk music. Well, this will be clearly, at least formally, will be a kind of criminal norm respectful of the act requirement. But the sense of my example is that, in fact, this kind of criminal norm would have as its aim the fact of punishing certain kinds of persons. That is, those persons who typically listen to punk music because they are deviants, they are...
So that's not a violation of the act requirement, right? It's simply that the act that's being targeted is not wrong. So you know, like buying punk music, there's nothing wrong about it. The state has no legitimate interest in prohibiting punk music, insofar as one could not make an argument that it leads people to be violent and so on and so forth.
Yeah, but my point is not that, okay, but probably that's true, of course, but in my view is that this will be a kind of actor criminal law insofar as the real intention, as the real aim of the legislator would not be so much that of prohibiting the fact of buying punk music, but that of criminalizing certain kinds of persons.
So why do you infer that the intention of the state is to persecute these poor people of color who come in, presumably, over and beyond simply asserting and protecting its territorial sovereignty? Saying people come in on their own accords without respecting our rules, well, we're sanctioning this, right? Without having to go further and say, actually, we, the state, want to make a case of getting at these people because they are bad, because they're likely to corrupt our society, because they're likely to steal, because...
Yeah, in my view, the reason for saying that lies in the general regulation of immigration. That is, in the fact that the migration regulation is made in such a way as to make that only certain persons, certain kinds of persons, can qualify as illegals. That means that the problem, if you want, in a way, the problem is not so much with crime of illegal entrance per se, as with what lies behind the crime itself. That is the general way in which migration is regulated and legislated.
So your attack is not so much on the crime, but on the regulation of immigration per se.
Yeah.
Okay.
It's on the crime as applied in this kind of general regulation.
Okay. James, you had that.
No, that's okay. You guys sort of sorted it out through your exchange.
Sorry. Okay. Any more thoughts? Yes. Mike. Yeah, use this one.
This is new.
There we go.
Hey, I guess on the labor front, you said that it would not make sense for the at least the Italian government to deport the people because they do form a large part of the economy, the irregular economy, and that is a large part of the Italian economy, I guess. We've spoken about it before.
Yeah.
And I was giving the example of in the United States, it's part of illegal immigration is, I guess, is part of the most legitimate labor, the agriculture, and so like the food that Americans and that they export to us is grown by undocumented workers, and so there is an interest in the American government, I guess, to police it such that they can keep the labor costs low, and so they do that not through necessarily criminal sanction, although they do it. They'll do, I guess, document checks randomly in such a way. I mean, this is allegedly, but I think we can say that it's true that they do that in order to keep people in line, and they'll deport people that kind of don't keep in line. And I was wondering if that was how the Italian government, if they do anything in that respect as far as to police it, or if it's just good behavior in general, like if they get into irregular economy that's illegal, like drug trafficking, I guess, okay, that's easy, they send them back, and that's easy because it's actual legitimate crime. But if other things, like I guess it's a irregular economy, so I'm not sure if there's, like what that partakes, but is there?
Yeah, it's simply, I was simply referring to the fact that very frequently in Italy, official regular works, regular jobs are carried out irregularly without respecting all the norms that labor law imposes. And this is a regular job or labor or work and of black market, I don't know, to which I referred. And this is an important part of Italian economy. Also in the agriculture field.
In Italy also?
Yeah,
Okay.
also. And obviously irregular immigrants are a huge part of this irregular economy, because they frequently accept to do a kind of jobs of that Italian citizens do not want to do. And if there weren't irregular immigrants in Italy, this kind of jobs cannot be carried out, because no one wants to carry them out. And this would impinge on Italian economy.
So is there any indication that if that they use it as a sort of means to, stand up for their rights or anything like that, that the government will then act to deport them, or is it entirely just because of the threat of deportation and the additional, stigma of being criminalized that they just don't?
Yeah,
kind of,
yeah.
That's how it works. Okay.
This is the case.
Okay, cool.
Absolutely.
We'll take one last question.
Has there been any, like you talked about the kind of asymmetry of legal protections, due process, as Professor Stavropoulos was talking about, between immigration law and criminal law. And yet we have this reality that the consequences of immigration enforcement action are frequently equal to or greater than the consequences of punitive action. So the removal of someone touches core human rights interests: life, liberty, security of the person, all of these kinds of very core fundamental human rights. So there have been efforts here, and I'm not sure if this is my question, if there has been similar in Italy, efforts to tie the consequences of immigration enforcement action to try to create a larger set of procedural protections in the administrative immigration realm.
Oh, sincerely, I really don't know.
Right.
If this is the case. I should check it, but I have no answer to this question. Sorry.
Yeah, no, that's okay.
I
It's
do
been
not-
largely unsuccessful here, so it probably has been there as well. It's the way in which immigration law occupies an outer realm of illegality, really.
On this note, please join me in thanking Professor Spena for a wonderfully thought-provoking talk. Thank you very much.
Too much generous.
Thank you. That was great.
Very good.
Thanks to you.